everyone. Thank you so much for joining us this evening. It's 9 p.m. in Kampala, very hot. My name is Edith Twinamatsiko. I'm the founder and executive director of African Women in Arbitration. So our discussion this evening, it centers on a critical question in construction arbitration. What matters more when selecting an arbitrator? Is it technical expertise or subject matter experience and competence? And we all know construction disputes are often complex. They involve multiple disciplines such as engineering, architecture, quantity surveying, and law. So while technical experts, bring this deep knowledge in their specific fields, they might not always possess the broader subject matter competence, which is required to navigate the nuances of arbitration. So, and we know that an arbitrator's role is not to provide technical opinions, but to decide both law and fact, applying relevant principles to the issue in dispute. So this evening, we'll explore why a well-rounded understanding of construction contracts, industry practices, and dispute resolution methods is essential for arbitrators. And we'll also examine how subject matter competence, rather than the high-end technical specialization, can reduce reliance on conflicting expert opinions, and which will lead to more effective resolution of disputes. So our speaker today will guide us through these considerations, including practical insights on skill acquisition and professional development for construction arbitrators. So as you can see, it promises to be a very enlightening session for everyone involved in arbitration and construction. And if you have any questions during the presentation, kindly post them in the chat and then our speaker will answer them after. So allow me to introduce today's speaker, Mr. Emmanuel Dike. He's a senior partner in the law firm of Jasmine Advocates, which has offices in Abuja and Lagos. He's an experienced construction and energy lawyer, as well as an arbitrator. And he has been appointed as a construction arbitrator and adjudicator in many cases. He's a pioneer general counsel at the Regional Center for International Commercial Arbitration in Lagos. He's also the chairman, Society of Construction Law, Nigeria, and the Secretary General, Institute of Construction Industry Arbitrators. Welcome, Mr. Dike, and the floor is yours. Thank you.
Thank you so much, Edith. You have almost presented my paper for me in that summary. That's quite interesting. In a very short time, we were able to grasp the essence of the paper. So we are a little behind schedule. So I will try as much as possible for us to make up the lost time. As you can see, on the screen, we have introduction. You already know the topic. So introducing the topic, we say that the choice of a construction arbitrator requires a measure of exposure to construction for the proposed arbitrator. Now, the degree of exposure required depends on choice of language in the arbitration agreement. Technical experts, though exposed to construction, may not have the requisite subject matter competence. So that's the introduction. And though we identify that experts are very vital in arbitration, because over the years, the use of experts in arbitration have been a vital component of arbitration. Sometimes experts are indispensable in arbitration, especially in specialized arbitration, such as construction arbitration. Next. Now, technical experts include engineers with all manner of their specialist skills, electrical, mechanical, petroleum, and all that. a lot of specializations in engineering, and as we go along, you will see why we are trying to identify the specialist skills in engineering. And then next is architects, followed by quantity surveyors, and lawyers also, and estate surveyors. Sometimes lawyers are not, they are relegated to the background, but in the construction disputes, because of the complexity of construction disputes, it has become more and more important to get lawyers involved at the early stage of any construction arrangement. The use of technical experts in construction arbitration, how do we use these technical experts in construction arbitration? Experts render opinion and reports, and this opinion is highly specialized. The opinion may or may not be adopted by the arbitrator, and expert opinion is not enforceable as an award. And again, expert is not the arbitrator in a construction arbitration. This is very important. And it leads us to the next slide, which is, so who is the construction arbitrator in this circumstance? We said the construction arbitrator, the arbitrator is the one who decides both law and facts. Is expected to have a basic understanding of construction industry contract, both laws, regulations, and practices across board. Therefore, a basic understanding of the nuances of the dispute is required. So should a construction arbitrator not therefore be a technical expert, having all these qualities that we discussed in the previous slide? Shouldn't a construction arbitrator actually be a technical expert? And we try to say that no, a construction arbitrator need not be a technical expert. What is required of a construction arbitrator is the understanding of the subject matter to enable a full grasp of issues in controversy, as opposed to high-end technical knowledge that you usually find in experts. The ability to apply the relevant arbitration law to the issues in dispute is also important. So should a construction arbitrator not therefore be a subject matter expert? Putting the question in another way. We said no again, because subject matter expert deals with high-end knowledge in specifics in construction. For example, civil engineer is involved in what we call delay analysis. Structural engineer looks at the root cause of the defect. A marine engineer looks at standards. Architects looking at the design and as-built drawing for defects. Quantity surveyor looks at costs, and estate valuer looks at the valuation. So these are the various experts in a construction process. And because their knowledge is high-end in specific construction, we want to give you an example. For instance, the much celebrated Process and Industrial Development Limited, P&ID case, versus the Federal Ministry of Petroleum Resources as a Nigerian arbitration. It made rounds over a period of 3 to 4 years. And briefly, it's a contract awarded by Nigeria to P&ID for the supply of wet gas, although with high infrastructure provision content. Now, P&ID won in the arbitration, but the award was overturned by an English court on grounds of breach of Nigerian public policy arising from corruption in the contract award process. Now, a demonstration of the role of an expert in P&ID, which is what is important to us here, is that the expert witness in the case is an engineer, number one. Number two, he possesses specialist skills in oil and gas infrastructure. Number three, he had high-end knowledge in oil and gas market. He is able to forecast oil prices, whether it's rising or falling, so that he's able to guide his clients when to enter the market and when not to enter the market. And then in this particular arbitration, because it was expected to forecast for what could have been the profit of P&ID over a period of 20 years when the contract is supposed to have lasted. So he's able to use his knowledge of the market to come up with a kind of profit, future profit that P&ID ought to have made, which was what brought the arbitration award to about $6 billion. And the arbitrators, of course, adopted his report wholesale. So that's what actually gave Nigeria a problem in that arbitration. Now, subject matter experience and competence skills are required instead of being an expert. Yes, instead of being an expert with high-end knowledge to come and do arbitration, what is actually required is to acquire subject matter competence and experience skills, subject matter skills and experience across board, which is to say that basic knowledge across disciplines in the construction industry for a holistic grasp of construction dispute. Next. Why do we say so? That someone with a subject matter competence and experience needs to have knowledge across board. This because a single construction dispute is difficult to pigeonhole in one single issue. In a construction dispute, you could have issues relating to design, faulty design. You have issues relating to cost overrun. You could also have issues relating to supply of substandard materials. You see, so when you zero in on only one expert, who is probably an engineer, is only able to understand the dispute in part. If you say, okay, you want to move to an architect, the architect is also able to understand the dispute in part because he's concerned about design. You try to zero it on the quantity surveyor. The quantity surveyor is only concerned with costs without looking at the other aspects. So when you now appoint any of these individuals into your construction arbitration, and it so happens that the issues in the arbitration cut across various disciplines, you have a problem with the arbitrator understanding exactly the issues in dispute. So in that case, someone who has a broad knowledge across board, which we have described here as someone with subject matter competence, is much more suitable in a construction arbitration. Now, this person with subject matter competence will have a clear understanding of construction contracts. Now, this is the legal aspect of it now. Both bespoke contract and standard forms, because in construction contract, you have two types, bespoke and standard form. And the arbitrator should be able to understand the contents of each of these contracts. And then the same arbitrator should be able to have an understanding of how to interpret design drawings of the architect. The same arbitrator should also be able to resolve a plan, and at the same time, he should be able to understand bill of quantities or change orders, variations. So you can't find this situated in one professional. Again, continuing in interpreting, is also able to interpret what we call bill of engineering measurement and evaluation. I think this is peculiar to Nigeria. Is something that engineers use as their own bill of quantity that ought to have been prepared by a quantity surveyor. So the same arbitrator should be able to understand it and interpret it as well. And then you should also understand specifications in building and engineering contracts. A specification is a document that gives you the exact description of materials to be used, both materials and labor to be used in a particular piece of construction. So we need somebody who has an understanding of these documents. And again, you also have to understand the subcontracting, the difference between a main contractor and a subcontractor, as well as the various contracts between a main contractor and a subcontractor, and even subcontractors. And lastly, dispute resolution methods used in solving any dispute that may arise in the course of construction. So how do you now acquire this subject matter competence in construction? It's always through professional training, because subject matter competence is not presently taught in academic institutions as a full bouquet of course. So skill acquisition by way of continuous professional development by some specialized professional bodies in the construction industry is the way you can acquire subject matter competence. So and we can, I'll give you an example of the Institute of Construction Arbitrators, where you can acquire a full bouquet of this subject matter competence. Prof, is this the next slide?
Yes.
Okay, fine. Let's move on then.
Yeah,
yes.
Okay.
So now, in choosing an arbitrator with subject matter competence skills, how do you do it? Of course, it has to be in the arbitration agreement. The arbitration agreement has to be clear in the kind of expertise your construction arbitrator ought to have. And that is to say, you have to couch the agreement in such a way that it will capture the essence of having someone that has knowledge across disciplines, across board, in various aspects of construction, like we have identified in the previous slides. Because if you narrow yourself down to someone with experience in the construction industry, you may not get what you are looking for. And again, you say that, okay, you need an engineer to handle this dispute. And that dispute may not necessarily be about engineering. It may go beyond engineering. You may have cost issues. You may have supply issues. You may have materials standard and all that. So it behoves on the drafter of the contract to ensure that the arbitration clause captures someone whose knowledge is able to interpret the various facets of the dispute that may be presented by the parties. Now, this subject matter, because the subject matter of a construction dispute is not just confined to any particular field or profession. So that is the reason why you need to be very careful in drafting arbitration clauses that it has to do with construction contract. And when you have done that, you see that there will be a reduction in the frequent recourse to experts, because what is done largely is that experts are usually consulted when arbitration becomes more and more technical. So you consult an expert in that area and to deal with that issue, and the expert gives you a report. But what we are saying is that if the arbitrator is well informed in what the dispute is all about and is able to grasp it without looking for assistance, it reduces you going back and forth looking for one expert or the other, because I mean, the more experts you bring into your arbitration, the higher the costs. And then another danger about experts is not to is experts' opinion are the same usually. Sometimes when a conflict arises in expert opinions, the arbitrator might now say, okay, experts, you go and have a meeting and reconcile their opinions, and let's see the ones you agree on and the ones you do not agree on. So it makes the whole thing a bit complex when you now have to deal with so many experts, and you are also dealing with various opinions of these experts. And so the arbitrator who is not that knowledgeable as those experts is going to find be in confusion in doing justice to the dispute. So in conclusion, we'd say that technical expert, though highly skilled in his area of competence, may not possess the requisite skill for construction arbitration. So a party needs to choose a well-rounded construction arbitrator with subject matter competence skills across disciplines in the construction industry. And we say that there are specialized bodies in the construction industry that offer this opportunity for prospects to acquire subject matter competence skills. Thank you so much for listening. It's been a pleasure being given this opportunity to speak to you. Thank you, Professor Emilia. Thank you, Suas.
Thank you very much. Edith.
Thank you so much. I don't know if you have any questions. I haven't seen any in the chat, but perhaps you can unmute and ask a question.
Edith, can I start with the questions? Emma, I do have one question, which is, from what you have said, and I don't disagree, and that's my own experience as well. But the question is, how then do you get appointed? Because if you don't, from what you're saying to us, you're effectively saying that we should at least take some professional course or program that are in construction disputes, at least to have basic understanding. And otherwise, we shouldn't put ourselves forward. But what if somebody gets their first arbitration appointment and it is on construction? What would be your advice? They haven't done the training. They are not very confident because they have listened to your presentation, but they now have this appointment. So what would you suggest to them? What should they do? Because they've now been appointed as sole arbitrator.
Yes, that's even the challenging aspect, because most construction disputes come in as sole arbitrator. Yeah. So you do not have the privilege of leaning on the wealth of experience of other co-arbitrators. So as a sole arbitrator, it's a bit more challenging. You take it as it comes and try and do as much as you can. And the arbitration law of Nigeria allows you to also consult party. You can actually consult those who are experienced and use them as assistants. That's a provision for you to do so, but that is at the cost for the parties. The parties will now be the ones to pay the cost. The way and manner lawyers are hired to represent parties is also the way and manner you can also hire someone to assist you as an arbitrator in understanding some of the issues that may be thrown at you. Well, short of saying that it's not really compulsory that one accepts an appointment when you may have a lot of challenge in doing justice to that appointment. There's no compulsion. in accepting arbitration appointment because it's all left for the arbitrator. That's why there has to be an acceptance when the offer of arbitration appointment is made. And if you see, or if you know that you may have some difficulty or challenge in actually satisfying the expectations of required of you in that arbitration, there's no harm in recommending your next friend who might also give you an opportunity to understudy the process.
Yeah, I think I like the advice, which is to try and find either an assessor, somebody that knows that can formally support the tribunal, or and I like that second point, which is if you don't feel you're competent enough to deal with an arbitration when an appointment comes your way, you have a right to decline the appointment, and you can always suggest somebody else to the parties if you know. But I know that Fatima is on the call, but she's on the road. I know that Fatima will be interested in knowing about mediation, whether mediation is being used in construction disputes.
Very well. Yes.
Yeah.
Yes, mediation is also an option in settling construction disputes, and of course it depends on the willingness and good faith of the parties. And you know, arbitration in construction issues are time bound. You may not have the luxury of trying your hands on mediation, and if mediation fails, you go to arbitration. Any day that is spent in a construction project, it is a lot of money. Cost overrun, hyperinflation, and so many other variables involved. And that's why sometimes it will look like those involved in construction want a process that will give them a definite answer or a definite decision that can be enforceable, and so that they can continue with the construction project, because the essence of a construction project is to deliver the project, and on time too. Once you start missing deadlines, you are not able to meet your milestones. It's a lot of trouble for the client, that's the employer. It's a lot of trouble for the contractor, the main contractor. It's also a lot of trouble for the small subcontractors, because they actually bear the brunt of any delay in a construction project. So there is no harm in trying mediation, but then you have it at the back of your mind that something has to be done as to if parties do not accept the settlement that is the outcome of mediation, or if a party walks away, what happens? I do know that there is a Singapore Convention on mediation which tries to put some bite into a mediation agreement, but then that is still trying to be absorbed by the various signatories to the convention, and we're happy to see how it will play out at the end of the day as it concerns construction. Thank you.
Thank you. We have some hands. Mark, you can unmute and ask your question.
Thank you so much for this opportunity, Edith. Thank you for that. Thank you so much, Emmanuel, Mr. Dike, for that excellent presentation. I actually just wanted to latch on one of your last points, especially there when you were discussing the possibility. So if you're not a specialist, or if you don't have the requisite experience specifically in specialized arbitration such as construction, then it would be better for you to decline the appointment. But I just wanted to pick your brain as someone who's obviously has a lot of experience practically in this area. For a situation where someone is just coming in to arbitration, maybe it's the first few appointments, it's possibly the first appointment they would have gotten. In a situation like that, would it be better to sort of accept the appointment and ensure that you're able to educate yourself through, for example, asking, other people within the profession for guidance, and taking on that appointment? Or would you still advise that it would be better for you to decline that appointment given the lack of expertise and knowledge that you have on that area? And the reason I ask is just obviously, for people starting off in this area, it could be really difficult to get initial appointments. And so there tends to be that sort of hesitation to simply decline an appointment, especially where, for example, you've been sitting as a secretary for a while, and this is your first substantive appointment, and then it's not quite in an area which you have that much knowledge or expertise. Would you still say that it's safer to decline that appointment given the lack of knowledge and understanding in that area? Thank you so much.
All right, thank you, Mark. Yes, declining is just an option. The first option I gave was for you to seek assistance from those who are experienced. Most arbitration laws allow you to seek assistance, maybe get assessors or some other person that is knowledgeable in that field to assist. As long as it's not the one that will take the decision, you are the one to take the decision, and you put it across to the parties that you need assistance in this area, and parties will approve of it, and then you are good to go. Otherwise, it might be very challenging indeed for you to grasp the essence of the dispute if you plunge yourself into it, because the challenge is going to be yours, actually. And though parties will bear the brunt, but that is their own making. Arbitration or arbitrators are appointed for better or for worse. If anyone appoints an arbitrator in a dispute that might be challenging to that arbitrator, then you have to swallow whatever the arbitrator comes out with. That is the other side to it. So a lot of you need to be very careful in choosing who comes on board as your construction arbitrator. That's just the message there. You need to be careful. But beyond that, if you are ready to waive everything and still insist on the person being your arbitrator, then whatever comes out of it is your choice.
Thank you so much for that.
Okay, thank you. I hope, Mark, your question has been answered.
Yes, thank you.
Okay. Ima, kindly unmute and ask your question.
Yes, thank you. Hello, everyone. Thanks to the organizing team, especially Emilia, and thanks, Emmanuel, for this excellent presentation. Of course, I love the topic because I love the construction projects, especially where I am based in GCC countries. There are many complex projects in relation to construction. My question is not just about how to be appointed as an arbitrator in construction sector. My question is more general, how to be able to act as, successful both counsel and arbitrator in construction projects. I know that experience matters. For example, I myself, comparing to 2 years ago, that by experience, by being involved in some cases, I know more about, for example, I don't know, methodology for EOT, I don't know, reports or expert reports. But, one thing is about procedural issues like FIDIC and, I don't know, procedural issues related to construction. But the important point, as you correctly mentioned, concerns the substantive technical issues. We are not engineers. We are mostly coming from, legal background. So how can we improve that substantive part of, the construction cases, even when acting as a counsel? Is there a specific course, professional one, a specific authority? If you can recommend, I'd be grateful.
Yes, I think I mentioned one or two, sorry, towards the end of my paper. And I said that it's not a course that you can readily find a full bouquet in the universities, but some professional bodies have taken it upon themselves to actually package construction what the basic knowledge you need to understand and analyze a dispute as an arbitrator, as counsel. They package it and in form of subject matter competence, skills acquisition, training, and those courses they cut across board. Basic understanding of what an engineer does and the way he looks at issues, basic understanding of what an architect does, basic understanding of what a quantity surveyor does, and then basic understanding of the various construction contracts that are available. You mentioned FIDIC, yes. FIDIC is a form of standard form contract. And then the other side to it is bespoke, which is usually for a very large scale and complex projects. And so many other forms, like you mentioned GCC as well. And then in America, in the US, they have their own the forms, and some big corporations also have their own standard forms that they use. So you have a myriad of contractual documents in the construction matter, and each apart from the contract themselves, some other documents that are contractual also form part of the contract. So you see, that brings me to another point, that in a construction dispute, you do not find the construction contract in a single document. It may be scattered in so many other documents and incorporated by reference. And so and apart from that, you have so many volumes of emails to deal with, and each of them has contractual effect. So and the way and manner you are going to deal with these issues, it will be of assistance for you to have some background exposure before delving into some of these issues. So I'm sure that my paper will eventually be circulated. You'll see some instances I have given of where you can acquire some of this knowledge and skills as well.
Thank you very much.
Okay, any other questions before we bring this to a close? Comments?
Can I come back, Edith? And it would be great. I've known Emma has been involved in arbitration for almost 3 or more decades. So, Emma, we do have young practitioners on the call, young colleagues who really want to get into arbitration, and they would want to get appointment and to start learning and honing their skills. What advice would you give to our young colleagues on the call? How can they go about getting this elusive appointment? Any thoughts, any ideas would be helpful.
Okay. The appointments really elusive, but then first of all, as young practitioners, they should attach themselves to more exposed and experienced practitioners to act as either registrars or secretaries. Here in Nigeria, you can hardly do any arbitration without having a registrar or secretary. And I'm happy that the practice is gaining ground in some other jurisdictions. But for those who have not yet started making use of registrars or secretaries, my suggestion is that they should, because there are so many advantages to the young practitioners and even to the arbitrator himself. One, the young practitioner will learn firsthand how this kind of disputes is dealt with. And then the part of the arbitrator it shouldn't stop at just using the young practitioner as someone who collects documents for you. At the end of each session, you try and have a review with the young practitioner. Try to pick his opinion. Okay, you saw what happened in today's proceedings. What do you think about this? What's your general impression? Just to help the young practitioner, because I see that kind of learning is very, very effective, and the practitioner learns on the job faster than when you just see the young practitioner as someone who is just there to receive documents and send out documents. Should go beyond that. Then training is very important. It's key. Fortunately, most of the skills development training in this area is run online. So it's easier for anyone to key in from wherever you are and get, acquainted with the knowledge that you are seeking. It could be in arbitration, and it could also be in adjudication, because adjudication is also gaining ground as another good method of settling construction disputes. I know that, Prof, in your jurisdiction in England, adjudication is given a pride of place, especially in the NEC 3 contract. So and NEC is becoming more and more acceptable now. And then FIDIC also dealt with adjudication in their own way, and they call it DAB. In the 1999 edition of FIDIC contract is called DAB, but in the 2017 edition of FIDIC is called DAAB. DAB means Dispute Adjudication Board in the older edition of FIDIC contracts. Now, DAAB in the newer edition of 2017, it means Dispute Avoidance and Adjudication Board. So when you are using the new FIDIC edition, the 2017 edition, and you want to make use of adjudication, is a bit complicated, because the same adjudicator may want to be used sometimes to give advice, non-binding advice, on the strength and the weaknesses of the issues in dispute, and present it to parties just to help them come to an agreement. And again, the other side to it is that same person that is giving advice may also transform into an adjudicator. So that's why I say it's a bit complicated in the new edition. In the older edition, where the DAB is just there to settle any dispute arising from the construction, and by the way, a DAB is usually appointed as soon as a contractor mobilizes to site, because the DAB himself visits the site from time to time to tackle or to listen to issues before they become disputes. And if they become disputes, he handles them right away, gives his decision, so that the project does not stop. Because, like I said before, it's very, very problematic, allowing a construction project to stop once it stops, a lot of issues crop up. And once it's like that, you could say that the cost of dispute resolution might be about 1/3 of the entire cost of the project. And so it gives a lot of problem, you know, in that respect. So sorry, I deviated a little talking about DAB. Your question is just an arbitration, but I just had to mention DAB as well, adjudication, because it's also gaining ground. And anyone that is interested in construction arbitration should also have an ear on adjudication as well, because that is another area that is fast becoming the norm in the construction industry.
You're absolutely right. For us here in England, it's effectively, there's hardly any domestic construction arbitration because they all go through adjudication, and that's faster. Edith, back to you. Thank you very much, Emma.
Yes, so maybe just as a follow-up to Professor's question, you know, young practitioners may look at it as a very complex area. So my question would be, because you've said so many things, someone who wants to start out, what would be like the minimum, you know, training requirement? I remember when I was just starting to study the arbitration courses, and then I approached someone, and at that time I think I was still associate member, and you know, they said no, first become a member. So in that way, maybe you can guide what would be the minimum, you know, training requirement or the level of knowledge you to have before you start out in this area.
Very well, very well. Well, the knowledge for me, let's say you were an associate and then later you become a member, I believe it's in an arbitration institution or something, professional body. Yeah. So like you have it in law, you go to university, you have your first degree as a general knowledge of law. And then you want to specialize, you scale it up or scale it to masters, where you begin to look at a few certain areas of law critically, and then you can move on again to another level to specialize. So it is also in arbitration. You join an institute, they train you generally in arbitration. They don't have any, they do not tilt their training towards any particular sector. So you have general knowledge of arbitration, but that's not enough to deal with construction disputes. You also need basic knowledge, at least, of construction to understand parties when they're talking. Because one thing with arbitration is if once parties perceive that you are not understanding them, okay, that empathy is removed. So you must always have it at the back of your mind that if I'm faced with these issues and parties begin to talk above my head, what am I going to do? And you keep asking, saying, "Oh, what did you say? What do you mean? What do you know?" And then next, you go and get an expert who is probably he has already narrowed down his knowledge to specifics, and he gives you volumes of his opinion, which might even end up confusing you the more. So, but if you are able to have a good background of an appreciation of the sector, you see how you'll be flowing with the parties and you'll be asking relevant questions. You seek relevant clarifications from them, and they're happy with you. And sometimes they settle the dispute, like the one that I dealt with a few days ago. And the lawyer on the other side was uncooperative for about 8 months until we were able to track him somewhere. The registrar tracked him and he said, no, he was about to board a flight. But the registrar said, okay, just for 2 minutes. The arbitration is already sitting. And for your information, you are on speaker. So everyone is hearing you. So he now said, okay, he will give us 5 minutes. And that 5 minutes, he ended up using it to tell us his grievances, how the other opponent left the arbitration and went to court, So the matter is in arbitration at the same time as in court. And he said that was his annoyance. So that what we are doing in arbitration is already in court. So he never got to know that what the other lawyer had gone to court to do was just to preserve the rest, the subject matter. It had nothing to do with the merits of the dispute. So it was in that meeting, in that short telephone call, that all the clarifications he needed was made. And he was happy to come back to the arbitration. You see, so that is just the way I see it. So we need to have look at it specifically. I want to do construction arbitration. Let me develop myself a little more further in this area than to rely on general knowledge of arbitration that I have learned in my professional arbitration institute. Thank you.
Very well. Wow. Thank you so much. We've given you a virtual hand clap. Thank you, Mr. Dike, for that presentation, for taking your time and educate us more on this topic. Which, and on top of learning that there's a crucial distinction in construction, arbitration, and the balance between technical expertise and subject matter competence. We've also learned that, technical experts play an important role, and an arbitrator's ability to understand the broader picture of the construction disputes and apply arbitration law effectively is what really drives fair and efficient outcomes. Thank you so much to SOAS for organizing this. Professor, thank you so much. Thank you to all our participants on the call for your engagement to this. And we encourage you to continue to share your thoughts on this conversation and beyond this. And on behalf of SOAS, we appreciate your time, and we look forward to seeing you at future webinars. Over to you, Prof. I don't know if you have something to say.
It's just to say a huge thank you. Thank you, Edith. Thank you very much, Dike. That was really, really very good and very helpful for our participants. We're then also going to say, enjoy your end of year celebrations, get some rest, and come back refreshed. Our first event next year is going to be in January, and you would receive our newsletter. If you're not receiving our newsletter, please send us an email at sadrc@soas.ac.uk, and that should be fine, and we would respond. Thank you very much. Good night, everybody. Bye. Bye.